Well, what brought me here was number one, this ranch had always had a reputation for being probably the best ranch in the state of Nevada economically, historically. The ranch was actually started in 1865 with the silver boom that arose down here at Belmont, 18 miles south. And it was a reputation ranch. Never expected it to be for sale, but the previous owner had some problems relative to splitting up the property among various family members, and they just decided to sell the whole thing. So I came in and bought it. Prior to buying this ranch, we had a ranch outside of Reno, Nevada, northwest of Reno, Nevada. Actually, the property was just over the property line in California, so I'd have to say that I was a Californian for about 15 years. Prior to that, I'd been raised up in northeastern Nevada, in Elko County, and my family in one way or the other was involved in either mining or ranching from the time they first came in that part of the country, which was in the very early days of settlement. My educational background is I went through the 8th grade in Elko. I started high school, went about a year and a half, and found myself in the very hard winter of 1952. The ranches were having a very difficult time getting enough help to feed their cattle through the winter and get them to survive. And I talked my parents into letting me quit school with the promise I would come back and finish up my schooling. I think they thought I was going to do that the next year. Actually, I didn't. I stayed working on the ranches. At that time, there were still outfits in the country that would put out a roundup wagon that would stay out on the range for maybe 10 months out of the year. That was before they passed the Wild Free Roaming Horse and Burro Act in Congress and made outlaws out of all the Mustangers. And so if you weren't handling cattle, you could be running Mustangs, and for a teenage kid, well, that was the great life. I didn't want to go to school. So I didn't come back to school right away, but in an effort to stay out of the infantry during the Korean War, I enlisted in the Air Force. And while I was in the Air Force, they put me through some schools. And I also went ahead and completed my general educational development requirement. And with that, I was able to get into Boise Junior College a year or so after I got out of the Air Force. And then went on to the University of Nevada. And then went to Colorado State University. My major at the University of Nevada was animal science with a minor in chemistry, physiological chemistry. And then when I went to graduate school at Colorado State, I was in animal nutrition with a minor in economics. It was at that time that we were able to buy the ranch over in California from my first wife's family. And we moved over there, and I finished up my graduate work at the University of Nevada while I was living there on the ranch out of Reno. My graduate work, again, my major was animal nutrition, and my minor was economics. And I ended up writing my thesis actually in my minor, economics, because at that time in 1965, California had passed what they called the California Land Conservation Act of 1965, and even the legislature that had passed it didn't really understand what it meant, and none of us did, and I was caught up in it because it was a tax issue, and my property was caught up in it, so I was able to put together a committee in the county to study it, and based on the work I did in that committee, then I talked my major professor at the University of Nevada into allowing me to write my thesis on the California Land Conservation Act of 1965. As a result of that thesis, and I wrote it in the terminology that the average man on the street, man or woman on the street, could understand, and so therefore the legislature finally understood it. And as a result of that, the California Chamber of Commerce got a hold of me and asked me to join the chamber, and they would make me chairman of their agricultural land use subcommittee. So I was involved with the California Chamber of Commerce for a number of years until we bought this ranch and moved down here to Nye County. Pine Creek Ranch. It covers an area approximately 1,100 square miles. That would be roughly 760,000 acres, give or take. Pine Creek Ranch covers approximately 1,100 square miles, or if you want to put that in acres, it will come out somewhere around 760,000 acres. The main value right today, like with most ranches in the West, the main value is water. There has been an ongoing effort for years, and it's an international effort to gain control of fresh water supplies. And of course, in the western United States, the ranchers are the ones that own the vast majority of the water out here. There's an international effort to acquire water supplies because we have an expanding world population, and fresh water is getting more and more scarce, especially in the heavily populated areas of the world. And even here in the United States, given the combination of heavy population and the threat of pollution and the actual fact of pollution in many cases, fresh water is becoming more and more of a premium. I think right straight across the board today, and if you don't believe this, go down and buy some bottled water, but a barrel of fresh water is worth more than a barrel of oil. And so you can see the intensity with which many entities are trying to gain control of the world's water supply. Was at the heart and core of the litigation that we got involved with here on Pine Creek Ranch. When we came here, Las Vegas, the big city to the southeast of us, and of course Los Angeles, which is downhill from Las Vegas, were all looking for fresh water supplies. And so right from the beginning, we found that there was an attempt to take our water. Now, the way this materialized was the Forest Service came in and laid a claim to all of our water rights that we owned legitimately under state law and the prior appropriation water doctrine. And the Bureau of Land Management, of course, laid claim to the rest of the water. And at that time I said, wait a minute, I own these water rights. And under the prior appropriation water doctrine, if I own the water rights, that gives me control of the grazing lands. I own the forage out there too. And the Forest Service and the BLM, and when you sue one of those agencies, you end up suing the United States. So the case became known as Hage v. United States. The United States took the position that they could impose the concepts of the Eastern Riparian Water Doctrine on my ranch and on the West in general. And under that doctrine, of course, whoever owns the land owns the water arising on the land. Under the prior appropriation water doctrine, whoever owns the water controls the land, regardless of who owns it, in this case, the United States. And that control of the land in the way of a grazing easement, which was made possible by the existence of the stock water, the springs and seeps and creeks arising on the land. As a result of that, we controlled the forage and the grazing. That's an inheritable right and is known in law as ownership of the fee. So that's basically what led to the litigation in the first place was an attempt to acquire the water. What we have found is that usually the way these water grabs work in the West is you will have either the Bureau of Land Management or the Forest Service responding to pressure, which may be nothing more than propaganda. It may be a media blitz. It may be litigation. It may be legislation they've been able to get passed. The agencies will respond to that and then start regulating the rancher in a way that it becomes impossible for the rancher to make a living. And then when the rancher gets driven into the corner economically, and there's no one to buy him out because no one wants to buy that kind of a problem. And so then here comes another environmental group, usually called Nature Conservancy or Trust for Public Lands, and they ride in on their white horse to save the rancher from certain destruction and buy him out for pennies on the dollar, and he's lucky if he walks out with a shirt on his back. And then they have the ranch usually for the amount of the outstanding debt that he owed the loan company, and they have the water rights, and then, like in the case of Nature Conservancy, oftentimes they'll spin those water rights off to who wants them, and they'll spin off to the federal government what they want. And so basically the rancher's had his property stolen from him under the combined effort of the environmental groups and the federal agencies who basically follow the dictates of the environmental groups. Well, we find, and I can refer to a ranch over to the southeast of me here, where the attack on the rancher and his water rights was made under the guise of protecting the wild horses and burros under the 1971 Wild Horse and Burro Act. The way they went about doing it on that ranch is at that time, virtually every western ranch had a group of brood mares, maybe 20 or 30, maybe more, maybe less, that ran on the open range just like their cattle did, and that was the source of their new colts that they would then break to ride and use in the ranch work. When the Wild Free Roaming Horse and Burro Act was passed in 1971, the Bureau of Land Management then had control of wild free roaming, so-called wild free roaming horses and burros. And they placed a moratorium on any gathering of horses on the range. They said you might disturb the wild free roaming horses and burros if you go out there and gather your own horses. So as in the case with my neighbor over here, they kept that moratorium on for 3 years. And then they came around and told them, you can go ahead and gather your horses now, but you can only gather the branded horses. And so the ranchers said, well, look, we've got 3 years colt crop out there that has grown up. They're all the offspring of our mares, and those belong to us. When the Bureau of Land Management found out they couldn't get around that argument, they said, okay, you can go ahead and gather all your horses, but you'll have to pay a trespass fee on all those unbranded horses because you don't have a permit to run that many horses on the range. And so when they asked what the trespass fee was going to be, it turned out to be far more than what the horses were worth. And so most of the ranches just abandoned their horse herds, and the Bureau of Land Management had instant wild horse herds to manage. Now, in the case of my neighbor, that went on for years until what had been approximately 170 head of horses originally turned into an excess of 2,000 head of horses. They were eating his forage, they were drinking the water that he had to pump for his cattle at great cost, And he had to go to court to try to defend himself on that. He did win on the fact that the Bureau of Land Management had purposely allowed those horse numbers to expand to try to drive him out of business. And the court said that the Bureau of Land Management had to come in and gather those horses. But the objective there was that Mr. Fellini has extensive water rights and extensive underground water rights, and he's very close to Las Vegas, just like we are here. And if water will run downhill to Las Vegas, it'll run downhill to Los Angeles. And the power behind this thing is rather enormous. The big players are in this, not only nationally but internationally. Well, you can look on the state level, and we have found that people on the Supreme Court level in the state have been players in it, that senators have been players in it, congressmen have been players in it. You can look at a higher level, and you find various water companies buying water rights wherever they can acquire them. For example, my current wife, who was a member of Congress for 3 terms, Helen Chenoweth Hage today, had some clients in her home state of Idaho and in the Boise Valley. And they were having problems over their water and had hired her to advise them. And what had been the Boise Water Company had changed its name to United Water. And in their brochure they said, the only thing we've done is changed our name. That didn't sound right, so she had some due diligence done on that. They found out that United Water traces back to a French company called Suez, and Suez is owned by the United Arab Emirates. United Water owns all the fresh water in the Boise Valley right today. They own water throughout the United States. They own, or at least their brochure claims they own, all the fresh water in South Korea. And their brochure says that their objective is to become the largest water company in the world. So you have some real major players on the world scene, and Suez just being one of them. Well, when we talk about the start of this litigation, I pointed out that underlying the whole thing was the urge to get control of the water. Now, you have to remember that when we bought this ranch, 1978, that was the same year that the U.S. Supreme Court ruled in a case called United States v. New Mexico. And the issue in that case was that the United States Forest Service had tried to impose the Eastern Riparian Water Doctrine on a forest in New Mexico. And under the Riparian Water Doctrine of the East, which doesn't apply in the western states, whoever owns the land owns the water and everything growing on the land. And so their argument was, we own the land, therefore we own all the water rights on the land, therefore we own all the forage. The ranchers don't have anything here but a conditional privilege we grant them through a permit. And so that went all the way to the United States Supreme Court. The United States Supreme Court disagreed. The United States Supreme Court said out west there, that land was settled under old Spanish-Mexican law and the prior appropriation water doctrine, and whoever controls the water controls the land, regardless of who the underlying owner of the land is. And therefore the ranchers own the forage out there on that range because they own the water rights. And it was that case that caused the Forest Service and the Bureau of Land Management to intensify an effort then to acquire the water rights under state law. And that's when they came in here, 1978, and I was a new kid on the block. I just bought this ranch, and they decided they would lay claim to all of my water rights, and they would say that they had a priority right based on the fact that the Southwest was acquired from Mexico under the Treaty of Guadalupe Hidalgo in 1848, and therefore that gave them a prior right. Now, of course, we went to court, And the court said, no, that won't fly. The Forest Service didn't even exist in 1848. Neither did the Bureau of Land Management. And Hage's rights have been established since 1865 under the prior appropriation water doctrine. So here we were with the United States claiming they owned all the water and forage on this range, and myself claiming that I owned all the water and forage on this range. The court ruled that all of my water right claims for stock water and irrigation were valid, and the court didn't recognize any of the claims of the United States. That's the simplicity of the case. The government continued to argue that it didn't matter what my rights were. I still had to have a grazing permit before I could utilize those rights. And the court had ruled 3 times on that and said, no, Hage does not need a grazing permit. His rights pre-existed the Forest Service and BLM and any permit scheme they might have. And finally, the 4th time the United States went back to the well on that one, the court issued an order February 5th, 2003, and pointed out again that because my rights pre-existed both the Forest Service and the BLM and any permit scheme they had, that I did not need a grazing permit, or the way the court put it, because it's the United States Court of Claims, that any attempt to impose a grazing permit on me would immediately raise the issue of compensation. Simply translated, if they're going to impose a grazing permit on me, they're going to have to buy the rights from me to begin with before they have anything to permit. So that was the essence of the grazing permit issue. The issue of clearing the ditches was in 1991. And in 1991, in an effort to put me out of business, and keep in mind that we had been fighting this issue from the day we bought this ranch. The attack was on us from 1978 on. By 1991, the Forest Service had been able to impose enough regulations and increase our costs. Because what the Forest Service or BLM will do will bring charges against you over violation of their regulations. Now, this applies when you have a grazing permit. And it wasn't until we got into the litigation that I realized I didn't need a grazing permit. But they won't tell you that. They say everybody has to have a grazing permit. So under the permit and the regulations, they use those regulations to drive you into bankruptcy. And the way they do that is file some kind of a bogus charge on you over violation of the regulations. And then you have to appeal that. And to successfully appeal a Forest Service charge all the way up through federal district court, hiring a lawyer to represent you will usually cost somewhere between $50,000 and $250,000. Well, in 1990, I had 6 of those appeals that I had to deal with. They just keep stacking them on, stacking them on, stacking them on. Bottom line, we were broke, not only because of that, but because of the intensity of the regulation. We weren't able to run this ranch the way a ranch should be run. They will come in with a demand that you do things that absolutely defy common sense. And of course, that's for a purpose, because they know that either you can't comply or that you're going to have to comply at great cost. And what they're trying to do is drive up the costs and drive you out of business. So I was faced with that in 1990. And then the Forest Service announced that they were closing the Meadow Canyon allotment, which I own. I own all the water and all the forage in the Meadow Canyon allotment. And like I say, the court pointed out that the Forest Service didn't own any water or forage there. But nevertheless, under the permit, they came in and they closed that allotment, and they said, now, any cow that gets across the line into the Meadow Canyon allotment will be subject to impoundment and sale by the Forest Service. Now, when you consider the fact that there's a 25-mile unfenced boundary between the Meadow Canyon allotment and the valley, and there's live water coming down canyons into the valley, there's cattle trails going up everywhere, it was an impossibility to keep cattle out of the Meadow Canyon allotment. And so I knew that all I could do was just liquidate my cattle and sell out and try to salvage what I could. And to complicate that, even to get the cattle back in to Monitor Valley where we could process them and get them ready for sale, every one of those 2,000 head of cattle had to cross the Meadow Canyon allotment to get in here. So they had us in a situation where it was impossible to avoid trespass. Now, that was the situation that existed in 1991. And you ask about the clearing of vegetation on a ditch right-of-way. I'll give you a little background on that. While the Forest Service was intensifying its effort to drive me out of business, they also were trying to bring charges against a fellow who was cutting wood in this area. He cut firewood for a living. And he normally would get permits from the Forest Service, and the Forest Service let him go to this area, that area, or some other area, and cut firewood. But in 1989, I had published a book that I'd written called Storm Over Rangelands. And while the U.S. Supreme Court thought it was good enough to order 6 copies of it, and there's a lot of law libraries around the country who have that book in their law library, the Forest Service and Bureau of Land Management and the environmentalists were just virtually frothing at the mouth over that book, because I laid out the lawful background for the establishment of private rights on these lands of the United States that go by the misnomer public lands. This woodcutter, a fellow by the name of Lloyd Seaman, got a copy of my book, read it, and he thought it was so good he ordered 17 copies, and he sent one to every western state governor. When the Forest Service found out he'd done that, they informed him that he wasn't going to get any more wood permits. So Lloyd came to me and he said, the Forest Service won't give me any more wood permits. Do you have any private land that I could cut wood on? And I said, Lloyd, I most certainly do. I have irrigation ditches that are grown up with pinyon and juniper and sagebrush and everything else. Some of them are grown up so thick that you can't even walk down the ditch, let alone get equipment down there. And we need to cut that vegetation back so that I can get in there and do my ditch maintenance. Now keep in mind, the Forest Service had prevented any ditch maintenance for years. They said you had to have a permit to do that. And there was a case in Colorado that went up to the 10th Circuit on that very issue and forced the Forest Service to back off because these ditches were here a long time before the Forest Service were here. We have every right in the world to maintain a ditch. Besides, I owned the allotment that the right-of-way crossed. So everything there, the water rights, the ditch, the right-of-way, the allotment that the right-of-way went through, all belonged to me. And so I said, what we'll do, Lloyd, we'll cut a swath here less than 50 foot on either side of the ditch. Clean that vegetation out of there. So Lloyd went in and started cutting this vegetation. As part of the woodcutting project, there was a little 40-acre piece up at the head of the Pine Creek Ditch and the White Sage Ditch that belonged to the former owner. It was a one piece of property that he didn't sell me. But I watched it for him, and he made an agreement with Lloyd. He said, I want to thin out the pinyon and juniper and the rest of the vegetation on that 40 as fire protection. So he said, I'd like you to thin that brush out of there if you would. So Lloyd was up there cutting on that private patented 40 that belonged to Howard Archularius. And here came the Forest Service. And they found Lloyd cutting up there, and they came back and tried to file a charge against me for cutting valuable timber on the National Forest. And I asked the guy, I said, where's this cutting taking place? And he gave me a legal description. I said, do you have a map? Let's look at a map. And he went back out, or sent a guy back out to his pickup to get a map, and they brought it back, and he read the legal description, and I said, where is that on the map? And Those Forest Service maps, their so-called national forest is all in green, and patented parcels, private parcels, are in white. So he read the legal description and pointed to one of these white patented parcels. I said, what does that white mean? Well, he said, that means that's private patented land. I said, what are you doing here then? So they were very disgruntled, and the two of them drove off. I drove out there a couple of days later to check and see what was going on. And when I got there, here was a big sign on the patented 40, on the edge of the White Sage Ditch, that the Forest Service had put up there. It said criminal investigation site, and they had the yellow tape, you know, like the police use when there's been a crime, around this site. Do not disturb. That site was a good 100 yards within the boundary of the patented 40. But they also conveniently had gone to the north boundary and picked up the red marker that denoted the boundary and moved it over to where their criminal investigation site would appear to be on the national forest. Now that's how that thing got started. And they did come up there and sent one of their Forest Service law enforcement people. Now keep in mind, the Forest Service, the BLM, neither have lawful law enforcement authority. They don't have it. And what they have are special investigators in the Forest Service. And those people are there basically to make sure that the ranger boy keeps his hand out of the till. They're there to do internal investigations of the Forest Service, to make sure their own people aren't stealing or doing something else unlawful. But they put a gun and badge on them, put law enforcement, and then they go out and try to harass the productive sector of society. So here was one of these guys up there attempting to cite Lloyd Seaman, and he cited him. He's cutting wood on a private patented 40. So Lloyd had to go to Las Vegas to make an appearance before the court. My wife and I drove down to back him up. 5.5-hour drive down. When we got down there, it had been dismissed. So we drove the 5.5 hours back. When I got home, I had a subpoena waiting for me, demanding that I appear before the federal grand jury to answer for cutting valuable timber on the national forest. Okay. Number one, there is no valuable timber here. The adjudication records show that there's no valuable timber anywhere in this area. There's what the Forest Service calls trash species, pinyon and juniper. The Forest Service and BLM over the years have spent tens of millions of dollars trying to destroy pinyon and juniper. Just a few miles away from where we had cut that pinyon and juniper, on the ditch bank, the Forest Service had burned hundreds of acres of pinyon and juniper trying to get rid of it. But now, because Lloyd was cutting it for firewood, it became valuable timber on the national forest. It wasn't on the national forest. It was either on a ditch right away or a private patented 40 that belonged to someone else. So I was asked to appear before the grand jury and testify. And prior to coming down, I was supposed to send any documents that related to this. So I got together all of my water right documents, water certificates from the state water engineer, a court decree that said I owned the water, I owned the ditch, I owned the right-of-way, I owned the grazing rights on both sides of the right-of-way. I owned everything. I even sent them a copy of the original 1876 survey of that ditch, packaged it up and sent it down to the grand jury. When they saw that I could prove that I owned it and that the charge was bogus, they brought in a Forest Service individual a week before I was to testify, had him tell the grand jury that there was no ditch, there was no right-of-way, that we had been cutting valuable timber on the national forest, and they indicted both Lloyd and I. Now, then we had to go to trial. A lot of things I didn't know then. What should have happened is I should have challenged the jurisdiction. I should have answered that complaint and pointed out that there was no law which made cutting firewood on private property a violation. I hired lawyers. They didn't understand that. And they said, you just go down there and plead not guilty, a jury trial. Bottom line, jury trial, the only thing the jury determines are the facts. The facts were all correct. We were cutting wood, and Lloyd was selling that wood. It was in an area that is surrounded in green called National Forest. They had our names correct. All of the facts were correct. The problem was there was no violation of the law, but because we went in and did what our lawyers told us, we didn't raise the issue of law. And therefore, all the jury could decide was the facts, and the facts were all correct. So we got convicted. Now we had to appeal that to the Ninth Circuit, and the liberal Ninth Circuit Court came down double hard on the Forest Service. In fact, the court came very close to sanctioning the Forest Service for bringing that issue in the first place. And bottom line, the charges were reversed. In other words, they never existed in the first place. But that cost a small fortune to get that overturned. We were broke anyway. We had to do it on borrowed money. That's another way that they use to grind you down and drive you out of business. And so that issue about the ditch right-of-way became a focal point in the taking case that we brought before the United States Court of Federal Claims and said, look, Judge, this is the way they do it. They bring bogus charges against you over your own property, make you defend, try to break you, et cetera, et cetera. The court took special note of the viciousness involved in that type of an approach in trying to drive somebody out of business. Keep in mind that all this time, the issue, the underlying issue was the water. We've got approximately 20,000 acre-feet of surface water up here. We control a tremendous amount of underground water. Now, throughout history, when I say history, I mean the ranching history of this area, that water for irrigation and stock water purposes is kind of at the bottom of the scale. But now that you have Las Vegas and Los Angeles looking at that water, now it becomes extremely valuable. If they can drive me out of business, buy this ranch for pennies on the dollars, basically from the loan company that holds the mortgage, then they have possibly $100, $200 million potential water supply for maybe $1 million or $2 million. That's the strategy. And throughout the litigation, regardless of which way we go or what side we look at, it will always come back to that focal point. Somebody wants the water. And we know that Las Vegas Valley Water District at that time was called, it was called Las Vegas Valley Water District. Today it's called Southern Nevada Water Authority. We know that they have been looking in this area for water. It was very interesting when we were in trial on this case on the taking phase, and that's how the United States went about taking the property and what they owe. That the U.S. attorney, lead U.S. attorney on the case, who's a nice guy, I like him personally, in a very calm, cool, professional kind of an individual in the courtroom, he only came alive 3 times where he really got excited, and when he got excited, he got real excited. He came right straight out of his chair. And that's when one of our witnesses was asked the question. He was a water engineer, and he said, have you ever discussed with Southern Nevada Water Authority whether they have any interest in Pine Creek Ranch water? And actually he had, and the guy with Southern Nevada Water Authority, an engineer down there, said, you don't suppose Hage would take $10 million for that place, do you? And so when he told us about that, we said, we need to get that in writing so we can raise it in court. So we sent a proposal back to him to try to get him to put that in writing, and instead what came back was a letter from the Southern Nevada Water Authority's attorney. So the question was asked this witness on the stand. It said, what kind of response did you get back when you inquired about any interest that Southern Nevada Water Authority might have in the Pine Creek Ranch water? Well, he said, I got a letter from the attorney for Southern Nevada Water Authority saying they had no interest at all in any water of Pine Creek Ranch. And the lawyer asked him, he said, well, was that unusual to get an answer back from an attorney rather than from the engineer that you wrote to? And he said, well, yes, it was. And he said, well, why do you think that the attorney wrote you a letter? And the witness said, if I was an attorney for Southern Nevada Water Authority, I would have written exactly the same kind of letter. Why would you have done that? And the answer was because Department of Interior, Bureau of Land Management, has been working with Southern Nevada Water Authority for years to try to acquire water from the ranchers in the state for the city of Las Vegas. And the Bureau of Land Management and Department of Interior are parties to this suit. When he said that, this nice, calm, cool, collected U.S. attorney came straight out of his chair. Objection, objection, Your Honor. And the court said, well, what are you objecting to? The man's just testifying. I want this courtroom to know that there is no conspiracy between Southern Nevada Water Authority, the Bureau of Land Management, to take the water of Pine Creek Ranch. Well, he told us right there, as far as I was concerned, I think as far as the court was concerned, yes, there was a conspiracy. We didn't mention the word conspiracy. Now, 2 other times before the trial was over, when that issue came up, that was the only thing that brought that U.S. attorney to his feet. And all 3 times, he'd come right out of his chair and try to shut off any discussion of the involvement of the United States Department of Interior, Bureau of Land Management, or USDA Forest Service in trying to steal the water of Pine Creek Ranch for the benefit of Southern Nevada Water Authority. The U.S. attorney came right out of his chair. He's a cool, calm, collected guy, all the rest of the trial, but when that issue was raised, he came right straight out of his chair. Objection, Your Honor, objection. The court said, what are you objecting to? The man's just testifying. I want this courtroom to know, he said, that there is no conspiracy with the Bureau of Land Management, Department of Interior, and Southern Nevada Water Authority to take the water of Pine Creek Ranch. He told us all we needed to know right there. All right, you're asking me to tell you what the administrative appeals were about. And I don't know if I can recall all of them, but I'll give you some of them. They had demanded in 1990 that we get all of the cattle out of the Meadow Canyon allotment. Well, actually prior to that, they'd given the order they were closing the Meadow Canyon allotment. They were going to do that, so we had to appeal that. Then they followed right up and demanded we move all our cattle off in the middle of the grazing season. Well, if we move them down here in the valley, there's no fence between the mountains and the valley, the cattle will go right back. So it was impossible to comply. So then we were charged with a violation of regulations over that. We couldn't comply. Now, we also had on the other side of the ranch, on the eastern side, on Table Mountain, the Forest Service had reduced the number of livestock that we could put up there. And the reason they reduced the number of livestock that we could put up there was because they argued that there was range damage. That's always the catch-all term they use, overgrazing or something like that. Later on, they had to back completely away from that, and their star witness testified there was no range damage, which of course we knew. Their charges don't have to mean anything. The object is to try to get you to spend money to defend against them. Then at the same time, because of that issue, I said, I'm not going to put any cattle up there, because if I put cattle, regardless of what I do, I'm going to get another charge against me. So I didn't put cattle up there. So then they charged me with the failure to fill out the right form to not put cattle up there. They charged me for not having cattle up there, and I didn't fill out the right form asking their permission not to put cattle up there. So I had a charge against me now because I failed to put cattle on Table Mountain. But in August of that year, I think it was August 6th, there was several of us down here working on a windmill in the valley. We saw a Forest Service vehicle drive over to the gate that goes on to the Meadow Canyon allotment. And because cattle were used to going up on the Meadow Canyon allotment every year, there was always a group of cattle that were laying around that gate looking for a way to get on the allotment. We saw the Forest Service pickup go over there, stop at the gate. It was too far away to actually see somebody get out and open the gate. But then the Forest Service pickup turned around and drove away and came back and went back to Tonopah. I drove over there the next morning, and there'd been a little rain, so you could tell that there was only one set of fresh tracks, the Forest Service tracks. They'd driven up to the gate. You could see where a guy got out, opened the gate, and allowed all those cattle to go through on the allotment. So now I got charged again with trespass because I did have, I think, 23 head of cattle on the allotment. So I was trespassed once because I didn't, let's say I was charged for rule violation once for not having cattle on the allotment, and then when a few head cattle were let on by the Forest Service themselves, then I was charged with trespass for having cattle on the allotment. So we had that type of thing was going on all the time. Now I remember one time right when I first got here, and I believe the year was 1983. And at that time there had been 2 internal investigations of the Forest Service, because the Forest Service had been given word that there was criminal activity going on within the Forest Service, and they had their own investigators come in, and both of them ended up in a whitewash. I finally had to call for the 3rd investigation. But when the Forest Service found out that I might call for another investigation, all of a sudden in one 105-day grazing season, I received, according to the court records, an even 40 letters, most of them certified from the Forest Service, charging me with rule violation, and an even 70 visits from the Forest Service, charging me with rule violation. That's better than 1 a day. There was a green pickup coming in and out of this yard every day, and sometimes a couple times a day.